Fels and Regia VPROV of Batangas. Facts: on January 18, 1993, NPC entered into a lease contract with Polar Energy, Inc. over 3x30 MW diesel engine power barges moored at Balayan Bay in Calica, Batangas. The contract, denominated as an energy conversion agreement, was for a period of 5 years. Article 10 states that NPC shall be responsible for the payment of taxes. Taxes imposed or calculated on the basis of the net income of Polar and personal income taxes of its employees and construction permit fees, environmental permit fees and other similar fees and charges. Polar Energy then assigned its rights under the agreement to Fels despite NPC's initial opposition. Fels received an assessment of real property taxes on the power barges from Provincial Assessor Loro C. Andaya of Batangas City. Fels referred the matter to NPC, reminding it of its obligation under the agreement to pay all real estate taxes. It then gave NPC the full power and authority to represent it in any conference regarding the real property assessment of the provincial assessor. NPC filed a petition with the LBAA. The LBAA ordered Fels to pay the real estate taxes. The LBAA ruled that the power plant facilities, while they may be classified as movable or personal property, are nevertheless considered real property for taxation purposes because they are installed at a specific location with the character of permanency. The LBAA also pointed out that the owner of the barges, Fels, a private corporation, is the one being taxed, not NPC. A mere agreement making NPC responsible for the payment of all real estate taxes and assessments will not justify the exemption of Fels. Such a privilege can only be granted to NPC and cannot be extended to Fels. Finally, the LBAA also ruled that the petition was filed out of time. Fels appealed to the CBAA. The CBAA reversed and ruled that the power barges belong to NPC, since they are actually, directly, and exclusively used by it. The power barges are covered by the exemptions under Section 234 of R.A. number 7160. As to the other jurisdictional issue, the CBAA ruled that prescription did not preclude the NPC from pursuing its claim for tax exemption in accordance with Section 206 of RA number 7160. Upon MR, the CBAA reversed itself. Issue 1. The petition is time-barred. Held yes ratio. Section 226 of RA number 7160, otherwise known as the Local Government Code of 1991, provides, Section 226. Local Board of Assessment Appeals. Any owner or person having legal interest in the property who is not satisfied with the action of the provincial, city or municipal assessor in the assessment of his property may, within 60 days from the date of receipt of the written notice of assessment, appeal to the Board of Assessment Appeals of the province or city by filing a petition under oath in the form prescribed for the purpose, together with copies of the tax declarations and such affidavits or documents submitted in support of the appeal. We note that the notice of assessment which the provincial assessor sent to Fels on August 7, 1995, contained a reiteration of Section 226. Instead of appealing to the Board of Assessment Appeals, NPC opted to file a motion for reconsideration of the provincial assessor's decision, a remedy not sanctioned by law. The remedy of appeal to the LBAA is available from an adverse ruling or action of the provincial, city or municipal assessor in the assessment of the property. It follows then that the determination made by the respondent provincial assessor with regard to the taxability of the subject real properties falls within its power to assess properties for taxation purposes subject to appeal before the LBAA. We fully agree with the rationalization of the CA, citing the case of Kalan Tavi, Office of the Ombudsman, where we ruled that under Section 226 of RA number 7160, the last action of the local assessor on a particular assessment shall be the notice of assessment, It is this last action which gives the owner of the property the right to appeal to the LBAA. The procedure likewise does not permit the property owner the remedy of filing a motion for reconsideration before the local assessor. To reiterate, if the taxpayer fails to appeal in due course, the right of the local government to collect the taxes due with respect to the taxpayer's property becomes absolute upon the expiration of the period to appeal. It also bears stressing that the taxpayer's failure to question the assessment in the LBAA renders the assessment of the local assessor final, executory, and demandable, thus precluding the taxpayer from questioning the correctness of the assessment, or from invoking any defense that would reopen the question of its liability on the merits. In fine, the LBAA acted correctly when it dismissed the petitioner's appeal for having been filed out of time. The CBAA and the appellate court were likewise correct in affirming the dismissal. Elementary is the rule that the perfection of an appeal within the period therefore is both mandatory and jurisdictional, and failure in this regard renders the decision final and executory. Issue 1. The action was barred by residential judicata ratio. Residential judicata pervades every organized system of jurisprudence and is founded upon two grounds embodied in various maxims of common law, namely, public policy and necessity, which makes it to the interest of the state that there should be an end to litigation, republici ut sit litium, and the hardship on the individual of being vexed twice for the same cause, nemo debet bis vexare et idem causat. A conflicting doctrine would subject the public peace and quiet to the will and dereliction of individuals and prefer the regalement of the litigious disposition on the part of suitors to the preservation of the public tranquility and happiness. This is in accordance with the doctrine of residential judicata, which has the following elements: the former judgment must be final, the court which rendered it had jurisdiction over the subject matter and the parties. The judgment must be on the merits, and there must be between the first and the second actions, identity of parties, subject matter, and causes of action. The application of the doctrine of residential judicata does not require absolute identity of parties but merely substantial identity of parties. There is substantial identity of parties when there is community of interest or privity of interest between a party in the first and a party in the second case, even if the first case did not implead the latter. To recall, Fels gave NPC the full power and authority to represent it in any proceeding regarding real property assessment. Therefore, when petitioner NPC filed its petition for review docket as GR number 165,113, it did so not only on its behalf but also on behalf of Fels. Moreover, the assailed decision in the earlier petition for review filed in this court was the decision of the appellate court in CAG.RSP No. 67,490, in which Fels was the petitioner. Thus, the decision in GR number 165,116 is binding on petitioner Fels under the principle of privity of interest. In fine, Fels and NPC are substantially identical parties as to warrant the application of residential judicata. Fels's argument that it is not bound by the erroneous petition filed by NPC is thus unavailing. Issue 1. Forum shopping exists in this case. Ratio: forum shopping exists when, as a result of an adverse judgment in one forum, a party seeks another and possibly favorable judgment in another forum other than by appeal or special civil action or certiorari. There is also forum shopping when a party institutes two or more actions or proceedings grounded on the same cause, on the gamble that one or the other court would make a favorable disposition. Fels alleges that there is no forum shopping since the elements of residential judicata are not present in the cases at bar. However, as already discussed, residential judicata may be properly applied herein. Petitioners engaged in forum shopping when they filed GRNOS 168,557 and 170,628 after the petition for review in GR number 165,116. Indeed, petitioners went from one court to another trying to get a favorable decision from one of the tribunals which allowed them to pursue their cases. It must be stressed that an important factor in determining the existence of forum shopping is the vexation caused to the courts and the parties litigants by the filing of similar cases to claim substantially the same reliefs. The rationale against forum shopping is that a party should not be allowed to pursue simultaneous remedies in two different fora. Filing multiple petitions or complaints constitutes abuse of court processes, which tends to degrade the administration of justice, wreaks havoc upon orderly judicial procedure, and adds to the congestion of the heavily burdened dockets of the courts. Thus, there is forum shopping when there exist identity of parties, or at least such parties as represent the same interests in both actions, identity of rights asserted and relief prayed for, the relief being founded on the same facts. And the identity of the two preceding particulars is such that any judgment rendered in the pending case, regardless of which party is successful, would amount to residential judicata in the other. Having found that the elements of residential judicata and forum shopping are present in the consolidated cases, a discussion of the other issues is no longer necessary. Nevertheless, for the peace and contentment of petitioners, we shall shed light on the merits of the case. Issue 1. The petitioner may be assessed real property taxes. Held yes ratio, the CBAA and LBAA power barges are real property and are thus subject to real property tax. This is also the inevitable conclusion, considering that GR number 165,113 was dismissed for failure to sufficiently show any reversible error. Tax assessments by tax examiners are presumed correct and made in good faith, with the taxpayer having the burden of proving otherwise. Besides, factual findings of administrative bodies, which have acquired expertise in their field, are generally binding and conclusive upon the court. We will not assume to interfere with the sensible exercise of the judgment of men especially trained in appraising property. Where the judicial mind is left in doubt, it is a sound policy to leave the assessment undisturbed. We find no reason to depart from this rule in this case. In Consolidated Edison Company of New York, Inc., et al. v. The City of New York, et al., a power company brought an action to review property tax assessment. On the city's motion to dismiss, the Supreme Court of New York held that the barges on which were mounted gas turbine power plants designated to generate electrical power, the fuel oil barges which supplied fuel oil to the power plant barges, and the accessory equipment mounted on the barges were subject to real property taxation. Moreover, Article 415 of the new Civil Code provides that docks and structures which, though floating, are intended by their nature and object to remain at a fixed place on a river, lake, or coast are considered immovable property. Thus, power barges are categorized as immovable property by destination. Being in the nature of machinery and other implements intended by the owner for an industry or work which may be carried on in a building or on a piece of land and which tend directly to meet the needs of said industry or work. Petitioners maintain nevertheless that the power barges are exempt from real estate tax under Section 234 of RA No. 7160 because they are actually, directly, and exclusively used by petitioner NPC, a government-owned and controlled corporation engaged in the supply, generation, and transmission of electric power. We affirm the findings of the LBAA and CBAA that the owner of the taxable properties is petitioner Fels, which in fine, is the entity being taxed by the local government, as stipulated under Section 2.11, Article 2 of the Agreement. Ownership of power barges. Polar shall own the power barges and all the fixtures, fittings, machinery, and equipment on the site used in connection with the power barges which have been supplied by it at its own cost. Polar shall operate, manage, and maintain the power barges for the purpose of converting fuel of NAPO core into electricity. It follows then that FELS cannot escape liability from the payment of realty taxes by invoking its exemption in Section 234 of RA number 7160. Indeed, the law states that the machinery must be actually, directly, and exclusively used by the government-owned or controlled corporation. Nevertheless, petitioner FELS still cannot find solace in this provision because Section 5. Article 5 of the agreement provides. Operation. Polar undertakes that until the end of the lease period, subject to the supply of the necessary fuel pursuant to Article 6 and to the other provisions hereof, it will operate the power barges to convert such fuel into electricity in accordance with Part A of Article 7. It is a basic rule that obligations arising from a contract have the force of law between the parties. Not being contrary to law, morals, good customs, public order, or public policy, the parties to the contract are bound by its terms and conditions. Time and again, the Supreme Court has stated that taxation is the rule and exemption is the exception. The law does not look with favor on tax exemptions, and the entity that would seek to be thus privileged must justify it by words too plain to be mistaken and too categorical to be misinterpreted. Thus, applying the rule of strict construction of laws granting tax exemptions, and the rule that doubts should be resolved in favor of provincial corporations, we hold that FELS is considered a taxable entity. The mere undertaking of petitioner NPC under Section 10.1 of the agreement, that it shall be responsible for the payment of all real estate taxes and assessments, does not justify the exemption. The privilege granted to petitioner NPC cannot be extended to FELS. The covenant is between FELS and NPC and does not bind a third person not privy thereto, in this case, the province of Batangas. It must be pointed out that the protracted and circuitous litigation has seriously resulted in the local government's deprivation of revenues. The power to tax is an incident of sovereignty and is unlimited in its magnitude, acknowledging in its very nature no perimeter, so that security against its abuse is to be found only in the responsibility of the legislature which imposes the tax on the constituency who are to pay for it. The right of local government units to collect taxes due must always be upheld to avoid severe tax erosion. This consideration is consistent with the state policy to guarantee the autonomy of local governments and the objective of the Local Government Code that they enjoy genuine and meaningful local autonomy to empower them to achieve their fullest development as self-reliant communities and make them effective partners in the attainment of national goals. In conclusion, we reiterate that the power to tax is the most potent instrument to raise the needed revenues to finance and support myriad activities of the local government units for the delivery of basic services essential to the promotion of the general welfare and the enhancement of peace, progress, and prosperity of the people.